Hello everyone and welcome to today's Mondac webinar in association with Steptoe, who will be exploring asset recovery and judgment enforcement with a focus on 2024 trends in the US and UK. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Stephen Davidson is described by clients as a real international statesman and handles high-profile arbitrations and complex business litigation across the globe. Steve serves as lead counsel to Fortune 500 companies and other large companies abroad in cases involving complicated and sensitive contractual issues and business matters. Notable clients call on Steve to litigate knotty issues through trial, master difficult facts, and pursue all available avenues to obtain a recovery. Michael Barat focuses on all aspects of commercial litigation, arbitration and mediation, as well as judgment enforcement, including many matters with a cross-border emphasis. Michael represents clients in connection with their efforts to obtain recognition and enforcement of judgments and arbitral awards in courts around the world, and in seeking pre-judgment remedies in these matters. And completing today's panel is Molly Fox. Molly partners with clients to successfully manage high-stakes litigation, arbitration, and regulatory matters in several industries, including railroad, financial services, telecommunications, and oil and gas. She has particular experience navigating the intersection of business disputes with regulatory obligations. Now, before I hand over to the panel to begin today's webinar, a quick housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and the panel will endeavour to answer as many of your questions as possible. It's now my pleasure to hand you over to Molly, Michael, and Stephen to begin. Thank you.
Thank you, Dan, for that introduction. And hello, everyone. Thank you very much for joining us. This is a subject near and dear to our hearts, asset recovery and judgment enforcement. The three of us have been doing this for quite a while, and it's a vast topic, but we've picked a few key subjects, updates, and I think important guideposts for successfully enforcing judgments and finding assets. It's great as lawyers when we win a case and get a piece of paper that says we won, and we take great pride in that, but our clients take even greater interest in actually getting paid and getting money. So our job is to turn that piece of paper into a judgment. Turn that piece of paper of a judgment into money. And it's difficult sometimes, and it's often expensive and time consuming, but it can be done even in the most difficult of situations. So Aaron, if you could move to the next slide. So this is an overview of what we hope to cover today. As I said, it's a big topic. We've taken bits and pieces of it off that we hope will interest you, satisfy the questions you have. And as Dan said, if you have questions along the way, put them in the chat. We'll try to deal with them as we go. And if we have some time left at the end, we can deal with them then. If we could go to the next slide. So in many ways, the most important thing in recovering on a judgment is having a plan. And that plan starts not just when you get a judgment, but when you're on your way to getting a judgment. We often get cases from other lawyers or clients after a judgment's been obtained. And when that happens, we often see there are some steps that could have been taken along the way to try to make payment more likely. Even in today's world, it is surprising to us sometimes that clients and lawyers even don't anticipate the often difficulties of payment. Some situations are obvious, like a sovereign that is awash in debt. But other normal business situations, people often don't anticipate that their adversary will not pay upon the judgment being entered, appeals exhausted, and so on. So it's really critical to develop this plan. And from our perspective, in many ways, after a plan, the most important things to focus on are Have patience, know that this is going to take money to fund, have good intelligence, and sometimes a little luck helps. An airplane that's left behind, or some asset that we find out about that the judgment debtor thinks is well disguised. So, those are really the key things. But as you see from the bullets on this slide, really, really think through your plan. And there are often forks in the road on how you try to recover and steps you can take. And as I said, really think about this while you're litigating against the opposition before you get a judgment. And we'll go through some of the steps in greater detail of what you can do. If you could go to the next slide, Aaron. And there's sort of two pieces to this big picture. One is sort of the legal side, and the other is the intelligence asset side. And think about the assets all along the way. Think about where the debtor, what kind of business they're in, where their assets are likely to be, where they do business, with whom they do business, because there are many ways to try to recover. Getting in the way of payments to your debtor, finding their assets. And human intelligence is something that can't be overstated. It has a little cloak and dagger quality to it, which sort of livens up the law practice some. But it's really important. And, in the 30 plus years I've been doing this, the number of investigators and people who are expert in this has really grown. And, the world is obviously so different now with so much information being publicly available to anyone. But you really need to find the right intelligence gatherer for your case. And there are a number of really good investigators and companies we work with. And some are better situated for certain kinds of cases. Some are better at human intelligence. Some are better at different parts of the world. And you really need to consider that as you go forward in this process. And as you can see from this slide, really assess the intelligence, think about where you can go, and use that as a helpful guide to moving forward and hopefully collecting. We go to the next slide. So again, under the general title of finding the assets before you start, here are some kind of big picture thoughts on U.S. prejudgment remedies and UK, England, and Wales prejudgment remedies. And we emphasize this because this, in many ways, is perhaps the most important tool that a judgment creditor can use, both during the pendency of a case, if you feel like there is an opportunity or a likelihood that the debtor's going to not pay. And then after the case is collected, you move on to, after the judgment is entered, you move on to post-judgment remedies. But in terms of pre-judgment remedies, as you can see from this slide on the left, we talk about attachment, disclosure, TRO, preliminary injunction, and then other kind of equitable actions like receivers, lis pendens. And even if you have an arbitral award or about to get an arbitral award, or even if you've just commenced the case, think about what kind of prejudgment remedies are available in state courts in the United States. The arbitral bodies have different mechanisms for provisional remedies, but most are not well suited for such remedies at the beginning of the case or before the case has been filed. For example, in New York, there's a statute that allows you to attach assets before an arbitration has been filed, and then there's a requirement that the arbitration be commenced within a short period of time thereafter. And we use that tool successfully to attach assets of Venezuela, a directly held subsidiary of PDVSA, for Exxon in the early 00s. Michael, when he was a young associate, was stationed at the bank all day waiting for our attachment order to be live from the judge so it could be served immediately before the money moved out. And that little episode is key, because it shows you have to think through where the assets are going to go, what kind of tool is the best one to use for that, and then how do you implement it. As I said, there's a cloak and dagger element to this, of not tipping your hand, but not being too early, not being too late. And oftentimes, you really have to thread that needle, and sometimes there's a little bit of luck involved. So those are sort of the big picture prejudgment remedies. And then Michael, maybe you can talk about the UK, England, and Wales prejudgment remedies, and take us through into a little more detail on those topics.
Sure. And thank you everyone for joining us. I think on this presentation, we have all the time zones covered, as I'm coming to you from Asia right now. So it's good evening here, good afternoon in the UK, and good morning in the US. But that really reflects how we approach judgment enforcement questions. One thing that Steve didn't touch on in the US, but that's in our bullet points, is that general freezing injunctions in the US are not recognized, particularly by the federal courts. So while you can secure specific property and assets pre-judgment in the US, you cannot get a general injunction that freezes assets in most cases. It's not readily available, which then leads you to think about what other jurisdictions have that type of remedy. And the UK, England, and Wales is well known for what used to be known as the Morava injunction, and now the freezing orders, freezing injunctions, both domestic and worldwide. The standards are laid out there and are pretty clear that you need to have a good and arguable case, that there has to be assets in the jurisdiction, that there's a real risk of dissipation, and then under the just and convenient is where the courts have some equitable discretion and may even consider jurisdictionally whether the respondent has enough connections to the UK to make it an applicable order. It is an extraordinarily powerful tool. And if you can get that right out of the box, including in support of other cases, so a case going in the US, you are really in the advantage as the creditor. The two other points, though, one is that UK, of course, is a loser pays jurisdiction. So if the order gets dissolved, you could have the costs of the other side, and almost certainly will be awarded costs against you. The other is that there are many legal systems in the world that follow the UK system or that originated from it, and freezing injunctions are available there too. One that comes to mind is Hong Kong. And pursuing similar relief in those jurisdictions that follow the UK model can be a really powerful tool.
And I would also add to that very excellent description of the UK that the loser pay thing is important to know, but is also something that obviously goes both ways. And a lot of times in cases we've had, the judgment debtor will appear and lose, and then try to sort of remove itself from the proceedings. And then you have an award, a cost order that is separately enforceable. And as Michael will talk about in a moment, in terms of the potential remedies and tools you have at your disposal in the UK, you have very powerful disclosure tools, which in many of our cases, ironically, have gotten the most bang for the buck because the debtor has refused to or didn't fully comply with these obligations. And then you have the contempt findings. So Michael, maybe you could talk a little bit about that on the next slide.
Sure. And I'll wait for the next slide to come up. But on the disclosure, I second what Steve said. Getting asset discovery, getting information about assets in the first instance, not only is it helpful for that there might be contempt or refusal, but it can also lead you to other places where you might try to secure or attach assets, or if assets are in the hands of third parties that might not be covered by the freezing injunction. I'm still waiting patiently for the next slide, but I believe we were going to talk about ex parte discovery. Is that?
It was up
No,
there
not
before.
quite yet. I think you've covered slide 7, so I'll jump in.
Okay.
I think that was what Michael was covering that Steve was talking about on slide 7. And so then I think we can move on to slide 8. So Michael and Steve have just laid out all of the things to be mindful of before you've assessed liability, before you've moved into actually obtaining your judgment. But now we'll jump forward and you've successfully won liability and you have a judgment. And then the question is how to recognize that judgment in the US, or if you have a judgment in the US, how to take that abroad. And the United States has not entered into and ratified any treaty or convention regarding a reciprocal recognition and enforcement of judgments. So to do that, to take a foreign judgment and have it recognized in the US, or the converse of taking a US judgment and taking it abroad, requires a new judicial proceeding. And there's certain issues to be mindful of. Foreign courts tend to be pretty skeptical of punitive damages awards and usually don't recognize default judgments obtained in the US. The US has looked at moving it to enter into the recognition and enforcement of foreign judgments in civil or commercial matters convention, and did in fact sign that convention along with 33 other countries, but it hasn't been ratified by the US, so it's not in force yet. So maybe someday we'll have a big change in how we do things about recognizing US judgments abroad. But for now, we're stuck with this idea of a reciprocal notion of comity. And so foreign courts will often look at principles of comity. Did the court that issued the judgment have jurisdiction? Was the defendant notified? Was there any fraud? Or is the judgment contrary to public policy in a process of recognizing the judgment? So
Yeah.
with that, go ahead,
Yeah,
Steve.
I would just add to that before we jump on to the next topic that, Molly's summary is very detailed and all inclusive on this topic. But, we've had a lot of experience in going in both directions, taking foreign judgments, bringing them to the US, and often taking US judgments and having them recognized, particularly in England. There's a lot of cases in which this has happened. So even though there isn't a treaty involving the United States, don't be forlorn. It can be done, but it won't be simple in the sense that the judgment debtor has an opportunity to raise particular defenses in your case. And the trickiest one in going to England and taking a US judgment over there is this question of personal jurisdiction. The English have, the way they phrase it is whether the party submitted, has there been submission? And that can get a little tricky, even if they've showed up, if they fought jurisdiction and lost, sometimes the English court will sort of relook at that, saying whether the defendant actually submitted to jurisdiction and whether you've proven it. And sometimes you need to have expert testimony from an American lawyer for the UK court. And these are done in the high courts, the commercial side. And it can be done, but it won't be quick in either direction. But as I said, with other countries, it's much simpler. Among European countries where there are treaties that allow for simple recognition. So Michael, maybe you can talk next about the judgment enforcement tools in the US. So we're in the US, we have a judgment. What do we do with it? How do we enforce it? What are our tools?
So the main method of enforcement of US judgments is a writ of execution, which allows you to seize the assets of the judgment debtor or to get debts owed to the judgment debtor in the hands of third parties. And to do that, you need to successfully know where the assets are. And once you go post-judgment, You get full American-style fishing expedition discovery for assets. And no non-US client likes American discovery until you're one with a judgment and you're looking for assets anywhere and everywhere. And US discovery is exceptionally broad once you're post-judgment to go after assets. And one tool in the toolbox is what we call ex parte discovery. And what this allows the courts to do, and there's not many cases out there, but practitioners who focus on judgment enforcement know this practice. And that is that you ask the court to be able to serve document subpoenas on third parties and delay the notice to the judgment debtor. This way, you can go after banks or other financial institutions or customers who ordinarily pay to follow the flow of funds without giving the debtor advance notice or simultaneous notice. And you can delay it by up to 3 to 6 months when they actually get service of the subpoena. And this gives you a real advantage in trying to identify assets and then be ready to execute, which is the best part to recover.
And
Anything?
Mike, there was a question that came up on judgment enforcement about enforcing a U.S. judgment in Dubai, and there have been recent developments there, starting I think at the end of 22, in which there were regulations implemented there to make it easier to enforce U.S. judgments in Dubai, and I know some of those have actually happened in the last.
That's right.
Go ahead, Mike.
Yeah, no, and I think Dubai is coming on and wants to be a real commercial center, another venue for arbitrations. They want to take advantage of some of the cross-border and international transactions that have been going through the UAE. And I think that there's been a deliberate policy choice there that if they're going to do that, they have to be able to be in a position and have a reputation that they're going to respect international judgments and international arbitral awards. And that's an emerging trend in that area of the world where I think you will see some more international arbitration and judgment enforcement.
I think if we go, thanks for that, Michael. I think if we go to the next slide, you may have covered all the next points, but why don't we take a look and you can tell us if we should move on from there, Michael, or if there's things to cover.
Fraudulent transfers and bail piercing, Michael. You could talk a little bit about.
Yeah. So often when you have a judgment, the judgment's only effective against the judgment debtor. And the question is, what if third parties have assets? And this breaks down to basically two overarching legal theories. One is fraudulent transfers. Has the debtor transferred assets into the hands of third parties without adequate consideration or at a time of insolvency, or in an effort to deliberately prevent creditors from enforcing their rights? In any of those situations, the courts look at that basically across all jurisdictions, and they will say that's actually the assets of the debtor, not the assets of this third party. And they let you go after those assets and either set aside the transfer or get a judgment against that third party directly, or in some cases, even just get the property itself. There are other cases where you have a judgment and now that judgment is an empty shell or was always an empty shell, where there has been an abuse in the corporate form, where you have an alter ego. And that's where you can pierce the corporate veil. Now, in some jurisdictions, that's very difficult. I would say that the US is probably the main jurisdiction where veil piercing is more common and is acceptable. Outside the US, you can do it, and we have done it, but the incidences of fraud or single purpose entity have to be really strong on the facts. but it is possible, even though many people will say not, it is possible to pierce the veil, to do so in UK or even in some of the island territories in the Caribbean and the like.
And this is a really important tool in your efforts to recover on a judgment, because there are most private non-sovereign debtors, they don't just have their money sitting in a bank account somewhere for you to get it. Even if they do have money in a bank account, it's usually not in their own name. And the ability to set aside fraudulent transfers and veil pierce is really critical. And you need, again, to be mindful of when and where do you want to do this? Do you want to do this in the underlying case? Sometimes it's sensible to sue not only the judgment debtor, but others that they acted in concert with and or entities of theirs, so that you can pierce the veil. It's also possible to do that in a post-judgment setting after you have a judgment against your debtor A, and then companies B. You later learn that debtor has assets in a variety of other companies. You can move in the judgment case post-judgment to seek to expand your judgment, following the proper procedures and service and so on, to have that judgment then be able to be held enforced against other entities. And typically you can take that judgment overseas, and you can even do this overseas. And sometimes it varies from jurisdiction to jurisdiction. Like the Channel Islands, for example, have this process, but when we've done it, we've used receivers there. Receivers are often very powerful tools to help you in collecting on judgments. These things often have a little extra cost. They take a little piece of the pie along the way, but they're worth it because they have a lot of power, and they're well regarded by local courts. So, veil piercing, fraudulent transfers, receiver, turnover orders, which are a particular specialty in the New York courts, are another very powerful tool to be used. So if we could go to the next slide and sort of change topics slightly. A very important aspect of this topic is dealing with sovereigns. Sovereign, it seems like there's always one or two sovereigns in the news who have defaulted on substantial debt obligations. We had a wave 20 years or so ago of Argentina. Then coming on the heels of that, we had Venezuela with all the nationalizations by the Chavez government. We're circling back on another round in Argentina, and there are a number of other less prominent debtors and less pervasive, like it's a one or a two off case, like you have an arbitral award they don't want to pay. I mean, those are somewhat simpler, and then you have the big situations like Venezuela, Argentina, where there's a race to the creditors, a race among the creditors. So, generally speaking, you need to remember that sovereigns enjoy immunity. Under the sort of Anglo-American system, absent an exception to their immunity, you can't sue a sovereign. The United States has codified going against a sovereign in the Foreign Sovereign Immunities Act, often referred to by the acronym of FSIA. And England has a very similar statute, the Immunities Act, that deals with going against sovereigns. And the basic rule is that unless the sovereign's waived its immunity, which could be express or implied, you can't sue them. There are the most typical in our field area where there's been a waiver has been where the sovereign has entered into a contract that has some kind of dispute resolution process, usually in arbitration, in which they've waived immunity. And that is a very well recognized worldwide exception to sovereign immunity. And there are commercial activity exceptions in the United States and in other countries, or if there's otherwise been a waiver. But people are often surprised by how difficult it is to go against a sovereign. Most countries, especially in the US and the UK, notwithstanding how much of a deadbeat a sovereign is, the courts are very deferential to the sovereigns, for sort of comedy reasons, and each jurisdiction not wanting their sovereigns to be dragged into court without giving them adequate process. And, from a judgment creditor point of view, the process is usually way more than adequate and due. It goes on and on and on. And Molly's going to go direct your attention to a particular case in a moment that shows how long this can go on. And all of you who have been involved in these situations know it's a laborious process. And
unless of course we're representing a sovereign, but otherwise.
Right. But and remember too that there's sort of two bodies of law here. There's the immunity to being sued, and then there's the immunity of execution on assets. And they're not exactly the same. And you can have the ability to sue and get a judgment, and then have a narrower field in which you can operate to execute on assets. Most countries, for example, accept diplomatic residences, assets from any kind of execution. In the United States, central bank accounts used for government business are generally immune. Not so in England, but if you can prove a commercial activity, a lease payment, for a non-embassy property, money used for commercial activities, you can get at it. Now, we talked a little bit about veil piercing a moment ago. Veil piercing is also a possibility and often a tool that's needed in the sovereign area, because you'll have a judgment against an agency or instrumentality of the government, or you'll have a judgment against the government, but the agent or instrumentality is actually holding the money you want to get at. So in the United States, it is possible to pierce the veil of the sovereign. And there have been some notable cases of that, which we'll talk about in a minute, the Crystal X case in particular. And the bank check factors are the ones, that's the name of a Supreme Court case that sets forth these factors and have been enforced in most jurisdictions. In the United States, DC and the DC Circuit is one of the areas one of the courts that has the most developed body of law here, because default venue against suing a sovereign in the United States is in DC, in the federal court here. So a lot of the law is developed here, some in the Second Circuit in New York, but DC is really the leading court for this. And we would direct your attention to a case that we've handled against Zimbabwe, that in that we successfully pierced the veil to be able to go against the country of Zimbabwe when we had a judgment against an agent or instrumentality. You can see from these factors what you need to prove. And you can prove it in pleading, and then in order to overcome a motion to dismiss, which is like what we did in the Zimbabwe case, and then you'll need to prove it with actual evidence to get a judgment entered against the different sovereign entities to be able to collect your judgment beyond just the judgment debtor. So special circumstances dealing with the sovereign, and you'll need to consider that. And one of the most important things that people are sometimes caught by surprise on is that absent an explicit waiver by the sovereign, prejudgment attachment, prejudgment remedies are not available against the sovereign in the United States. The law is not quite so black and white in the UK, which we'll talk about in a little bit. But here, that's the law, and you have to have an explicit waiver of sovereign immunity in order to be able to go after assets pre-judgment.
So let's talk about the Petersen case that Steve mentioned. It's a little example that's playing out right now in the Southern District of New York about judgment enforcement against a sovereign. So in this case, Petersen versus Argentina, Petersen and another Spanish investor brought a breach of contract claim when Argentina renationalized YPF, its national oil company, and didn't follow the provisions for a tender offer that it should have. The suit before trial went up to the Second Circuit about a Foreign Sovereign Immunities Act issue in 2018. And then it took until, and then there was summary judgment, and during summary judgment, Judge Preska found that Argentina, and not YPF, was liable, and so made a finding of liability and dismissed the case against YPF, and Then last summer, there was a trial as to the damages. How much were these two Spanish investors damaged? And ultimately, Judge Presca entered, after a trial on the damages, a $16 billion judgment against Argentina. Argentina's appealed that judgment to the Second Circuit, but we are now watching in Judge Presca's court enforcement against a foreign sovereign play out. There's special procedures that you have to take when trying to enforce against a foreign sovereign. The major takeaway is that everything against a foreign sovereign is much slower. It is a real game of being patient, like Steve said. So one of the things that happened was Judge Presca stayed the judgment enforcement to allow Argentina some time to pay. She wanted a minimal pledge of a guarantee, or minimal assets pledged, and for them to move forward with an expedited appeal. Argentina didn't follow through with the minimal pledge of assets. And so in January of this year, she granted permission to move forward with execution or with enforcement of the judgment. And that's something you need under the Foreign Sovereign Immunities Act. You need the judge to say that a reasonable period of time has passed such that you can begin enforcement of your judgment against the sovereign. And now, just this week, the parties are in another dispute briefing what the contours of post-judgment discovery look like. There is an attempt being made by the plaintiffs to pierce the veil such that they could go after assets of YPF. And to get that, or to understand what those assets are, they're now in a discovery fight with the plaintiffs seeking asset discovery from YPF. So definitely years more in the making, unless, like the last time 20 years ago, the Macri government came in and decided to satisfy those judgments. But absent some sort of refinancing or a regime change, it will be years in the making watching this process unfold.
And the only other point I would add to that summary is one thing that sometimes clients don't realize when dealing with sovereigns in the United States. When you sue a sovereign in the United States, 99 times out of 100, the sovereign moves to dismiss on immunity grounds, saying they didn't actually waive or there's some other infirmity with respect to the case you're trying to prove. And if that motion is denied, that is, the creditor wins, the motion to dismiss is denied, the sovereign has an automatic right of appeal. And typically in American cases, you can't appeal a motion to dismiss until after a judgment's been entered against you down the road. But with sovereigns, they have a special ability to stop the case, appeal, and stay the underlying case. And that adds anywhere from a year to 2 years to a case. And that in the Petersen case that Molly just described, that happened. So the Judge Prescott denied the motion to dismiss, found them not to be immune, and 18 months later, they came back. And so you have to add, in dealing with the sovereign, that little piece. So maybe we can change topics a little bit more to go into another important area here on arbitral awards. You know, many of your judgments will be through arbitral awards, either among private parties or against sovereigns. So Molly, if you could take us through some of the highlights of that.
Sure. Well, the good news is here the U.S. does have a convention. It actually has more than one. So there is the New York Convention, which many countries have signed on to and entered into force. And in the U.S., the New York Convention is Chapter 2 of our Federal Arbitration Act. And so that provides the process for recognizing arbitral awards. And somewhat shortcuts the process in making it, or at least laying out the requirements for that process. One of the things that we wanted to highlight on this slide was that one way in which the U.S. Federal Arbitration Act, Chapter 2, is different than other countries' implementations of the New York Convention is that it applies a 3-year statute of limitations. That within 3 years of getting your arbitral award, you need to move to turn that arbitral award into a judgment in the U.S. But the US courts have allowed a workaround, a judgment on a judgment. So the idea there being that there are other countries that don't have that 3-year requirement, and in the US, most states have a longer time to recognize a judgment than an arbitral award. So to take advantage of that, it's possible to recognize the judgment in a different country and then come to the US with, say, a UK judgment and have that converted into US judgment. And the lead case on this, again, is from the DC Circuit, like Steve explained, where default jurisdiction or default venue lies against foreign sovereigns. And in that case, what happened was there was an arbitration, and I think it was 2000, that happened in Paris. A judgment was issued. They took that Paris judgment to the UK quite some time later, 9 years later, I think, in somewhere in there, and they got a UK judgment, and they still weren't having any luck getting paid, so they wanted to come to the US. When they came to the US initially, the lower court said, no, you're out of time. But as it worked up to the DC Circuit agreed that you could, in fact, take that 2019 or the 2009 UK judgment and turn it into a US judgment.
And that's actually what we did in the Zimbabwe case that we cited earlier, both for veil piercing, and similarly here, there was an arbitral award that was turned into a judgment in Zimbabwe, which then we enforced here, even though it was outside of the 3-year statute of limitations on enforcing an arbitral award, since it was a judgment on a judgment, not a judgment on an arbitral award.
So this is what we do a lot, is enforcing. If we go to the next slide, enforcing arbitral awards and converting them into judgments. And every so often, working as a litigator, you think, like, if only I could tell people what to do when they were writing their dispute resolution clauses to save them years of headache. So this slide are those tips, ways in which I wish drafters of arbitration clauses could foresee the issues that end up delaying payment for years. So the first one is that in an agreement, you could select a particular venue and consent to personal jurisdiction in that forum for enforcing an award. Lots of times this is a challenge that we see. You want to go to a certain jurisdiction, but you're unsure if you'll be able to establish personal jurisdiction. Now, the FAA does have a venue provision, but that's not always where the assets are. So in this sort of lots of forethought, thinking about how you would ever enforce your judgment, you could pick a judgment where you think either there's a friendly jurisdiction for creditors' rights, like New York, or somewhere where you think the assets would likely be. A second piece of advice is to appoint an agent, an irrevocable agent, to accept service of process for enforcement purposes. We see this a lot, that it's hard to achieve service, particularly against foreign sovereigns. We at times have spent years trying to serve foreign sovereigns, and an agreement like this is permissible under the FSIA. And then the last point that I'd like all drafters of arbitration clauses to think about is how the interest rate's going to work. And can you contractually agree to a post-judgment interest rate? So what often happens is that an arbitral panel will set a post-award interest rate, so the interest rate that governs from the finding of liability until entry of a judgment. And that rate often is higher than our US federal post-judgment rate set by statute, which is right now at 5%. And what will happen normally, absent this agreement, on the day the court enters the judgment, that rate will take over and it'll be fixed for however long it takes you to enforce your judgment. So if you were to go take an arbitral judgment today or get it turned into a judgment today, you would have a 5% interest rate from the entry of that judgment forward for however long it took. And so often when we have these long time periods to enforce a judgment, you can see a post-judgment interest rate that's really out of sync with the current interest environment that the markets are in. So just three wishes if you're ever in a position where you get to draft a truly complete arbitration clause.
Before we move on to the liens, I saw there was a question in the chat about whether courts have found the FAA statute of limitations to be permissive rather than mandatory. And I think, some of the sort of legal literature and headline writing has made that proposition about being permissive. But really what those cases say are that there are some contexts in which the statute of limitations is not mandatory, like this one where you have a judgment on a judgment. If you're actually seeking to enforce straight up an arbitral award, you need to do it within that 3-year period. And I think, there are some courts that are uncomfortable with that, given the outcomes that can produce, but the permissive, to use quotes, that has been described really refers to ways around it, like this judgment on a judgment, not saying that the 3-year statute of limitations doesn't.
And I also do think I'm familiar with a lot of the language about the permissive limitations period coming up in domestic cases where Section 9 says that an award may be enforced, within a year. Domestic arbitrations are a 1-year period, and courts have split over that 1-year period and whether may in Section 9 is permissive or not. And until Congress takes a look at that or the Supreme Court weighs in, I do think that you'll continue to have a split. And depending on which circuit you're in on a domestic award, you may be able to enforce it after 1 year. That I think is different than the limitations period we're talking about here. And I'm not aware of New York Convention cases saying that the 3-year period is permissive, like there is on the domestic side. There very well may be, and I'll take a look at that.
That's an excellent point. And to bear that in mind, as Michael was alluding to, the FAA, the Federal Arbitration Act, codifies both the New York Convention and domestic arbitrations and enforcement and procedures in the United States. You have to be very careful whether you're dealing with Chapter 1 or Chapter 2 versus international versus domestic, because like this issue that Michael has pointed out and others, there are important distinctions between the two. So Michael, you want to move on to priority of liens and Crystal X, since we've got about 10-ish minutes to go.
Oh, talk about Crystal X in 10 minutes. Sure.
Yeah.
And more slides. No, what I would say on priority, and as the slide comes up, there will be a lot of points there, but in big picture, outside of insolvency, it remains a common law creditor's race. First in time is first in right. And that really played out in the Crystal X case, where you had a whole series of creditors who were suspended in their ability to pursue their rights because of OFAC sanctions. And once those sanctions were lifted, the court resolved the priority disputes with whoever was first in time, and even on cases that were filed on the same day, whoever had the earlier docket. And unlike insolvency, they are going to do a distribution that is like an ice cube tray. Whoever's in line first will get their claim fully paid first, and then whatever's the surplus will go on and on down the chain. Unlike in an insolvency proceeding where it's a pro rata distribution. And Judge Stark, who's overseeing the Crystal X sale, outright rejected any type of pro rata distribution, even though the sale of Citgo that's coming and all of these creditors who've been waiting years, there are more claims in line than there is expected value at the auction. And so that is priority of liens in a nutshell and trying to save some time. I yield back. How's that?
So let's go to the next slide, which is the Crystallex slide, and see if there's anything else you want to cover about Crystallex. Is that
In big picture, just so to the uninitiated, I mean, this is an enormous dispute involving Venezuela. There are many, many, many cases, obviously now present in the United States and overseas, dealing with various defaults by Venezuela. There are arbitral awards being enforced and contractual claims being enforced. And Crystallex has been present in the District of Delaware in the United States for quite some time. And essentially, this is an effort to get at one of the most substantial assets that Venezuela has that's available to creditors in the United States, that is Citgo. So with that, Michael, maybe fill in a little bit of the drama.
So with that backdrop, on the one hand, the case is extraordinary and it's big numbers and it's lots of creditors going after a huge company that's well known internationally and involves sovereign immunity. On the other hand, the tools that are being used are no different than any other judgment creditor occurring anywhere in the world. The judgment debtor had an asset, equity in a company. The court is going through a judicial sale. The court appointed a special master. It could have been a receiver. It could have been any sort of quasi-judicial official to run the sale, and the sale is going forward. The important dates that are coming up, the bids are supposed to be to the special master by June 11th. And the court has set a hearing on July 15th to sort of reveal those bids and determine which is the highest bidder. All the final sale is still subject to a final OFAC license, which is the U.S. government office in charge of sanctions. So all of this remains still subject to U.S. government approval. But this is coming, and many of the creditors had direct claims against PDVSA, the ultimate owner of Citgo, and many of these creditors had claims against Venezuela from international arbitration awards, and they were able to successfully pierce the veil to go after PDVSA and its main U.S. asset, its stock in PDVH, which is the ultimate non-operating holding company of Citgo in the U.S.
And the only thing I would add is that drama may not yet be completely resolved. You know, there's a lot of sort of geopolitical issues in carving up this Venezuelan asset that's a fully functioning American company. And we'll see this summer whether who bids, how much, and whether it goes forward. I think it probably will, but there could be a number of bumps in the road. Now, on to a topic that is important, but a little less worldly than this, which is dealing with the ability to get discovery in aid of an arbitration or other governmental proceeding in the United States under the statute 28 USC 1782, in which there have been some important developments recently.
Sure. Thanks, Steve. In 28 USC 1782, you may know it if you practice around the world, that the U.S. Has authorized U.S. courts to order people in the U.S. or residents to provide U.S.-style discovery for use in a foreign proceeding or international tribunal. About 2 years ago, the Supreme Court held that provision does not apply to international arbitration tribunals, in particular commercial arbitration tribunals. It only applies for governmental or intergovernmental bodies. But the question was left open is, where do ICSID and the ICC fall in this assessment? Are they governmental bodies, or are they more like commercial arbitration? And so that's an open issue that we see getting worked out in the lower courts in the US. We have two cases on the yes side where courts have ruled that ICC awards are in fact, or ICC proceedings can in fact benefit from 1782 discovery. And on the other side, we've had two cases in New York where courts have ruled that ICSID proceedings are not government or intergovernmental proceedings, such that those parties would not be entitled to 1782 discovery. One of them is on appeal to the Second Circuit, and we're awaiting a decision there. So this is something where further developments are to come. With that, I'll turn it back.
Those of you who have relied on this provision, given the way the courts have gone and what happened in the argument and the briefing and what the direction the Supreme Court held, I wouldn't hold your breath on being able to use discovery in ICSID cases or ICC cases. I think eventually it will be fairly clearly limited to true governmental bodies, not quasi-governmental bodies. And then in terms of other trends, there have been some recent developments in the UK on freezing injunctions against foreign sovereigns that Michael's going to take us through.
Okay. So this is the next slide as it comes up. For many years, Section 13 of the State Immunity Act, the SIA, it was pretty clear that injunctions were prohibited against foreign states. And then in 2017, there was a Supreme Court case that involved the Embassy of Sudan. And the UK Supreme Court said that if an immunity is broader than what is required by international law, that might infringe upon the European Convention on Human Rights, Article 6, the right to a fair trial. And so there was some window of hope that the immunity could be curtailed. Fast forward to 2022, and a group of insurers tried to get an anti-suit injunction against Venezuela, who were pursuing foreign suits involving the same issue. And the court there said no, an injunction, an anti-suit injunction doesn't offend any notions of law. And so the question is, with these two cases, is there room for an injunction? And as you go through the arguments, there might be a Section 13 argument, because the section on the SIA divides up relief by way of injunction versus subsection B, any process for the enforcement of a judgment or arbitration award. And the commercial purpose exception applies to process for enforcement and doesn't necessarily apply to relief by way of injunction. So there is an open issue there in the UK with these precedents for someone to seek to get injunctive help, to get a freezing or restraint order against a foreign state if it's in connection with the process of enforcing a judgment or arbitral award. With that, if we can go to the next slide, as we're coming down on our time, but we only have two more trends and Molly to wrap us up. But there is this Iranian tanker case, and the upshot of this case is that the UK court, in a fraudulent transfer, the asset was transferred to a state entity, and ultimately the court ordered, as a remedy, the direct transfer of the property directly to the judgment creditor. And I would expect that if you can do that against state-owned entities, that will be a powerful tool or remedy for creditors in the UK. Molly?
Speaking of powerful remedies, Molly, maybe you can talk briefly about this RICO case, and then I can wrap us up.
Sure. RICO is a really powerful statute in the U.S. It offers treble damages and attorney's fees, so everyone wants to bring a RICO case when you can. The problem is that the injury needs to be domestic, And so an issue that came before the Supreme Court last year was this question of if there was a U.S. judgment, here it was a Russian business deal that then was arbitrated in London, but ultimately recognized where the defendant had moved to in California. So there was a California judgment. If the judgment debtor then started doing things to hide those assets, was that a domestic U.S. injury, an injury to the judgment? And the court held that yes, in fact, that satisfied the domestic injury requirement, and we saw the RICO statute now can be used in enforcing judgments if those judgments have been injured in the U.S.
And that's an important tool to keep, that's sort of been added to the toolbox through clever enforcement. So that concludes our program. Thank you so much for joining us. The takeaways we would leave with you are judgment enforcement is an area that requires a great deal of specialization and thought and planning and patience and, unfortunately, money to finance these often difficult and time-consuming efforts. But if you do it right, you'll collect on your money. And of course, always pick the right lawyer. And we would suggest, why not us? So thank you so much for joining us, and enjoy the rest of your day or evening.